A warm welcome to your favorite show, Law and Order. We're discussing many areas to give you knowledge on law to let you lead a successful life without falling in trouble, without knowing the law. So, ladies and gentlemen, we were focusing about the land law, and we have done several programs previously to give you some insights, elaborations, descriptions, and even some pieces of knowledge that is very essential for you all to lead this successful land purchasing without letting in trouble. Because you all know, if you fall in trouble without knowing the proper law, although you have genuinely claimed that thing, although you have genuinely have that particular right, you have to sort it out after the courts. So that is a huge problem. So we advise you from this program to not to fall in trouble. So to do the honors, we invited Mr. Sapumal Bandar, attorney at law. Thank you very much, sir, once again for joining with our discussion. Right. Okay. So we discussed about land law and many insightful areas, and sir, like there are some more areas that you have suggested that it's better if we can emphasize. First, we'll start with the constructive trust.
Yes. Now, constructive trust is a principle where it had been recognized by the trust ordinance as well. So, in land transactions or in some land dealings, the actual nature of the land transaction can be camouflaged. Now, for an example, you know that deeds of transfer are being executed to testify, to confirm a purchase. So, once you purchase a property, you are entitled for a deed of transfer. That is, the seller would execute a deed in your favor by a deed of transfer. He transfers his title to you and also the ownership to you. But there are certain instances where deeds of transfers have been executed, but the actual transaction or the actual intention of the parties was not to convey the land to the buyer or the purchaser whose name appears on the deed. Now, it can happen in many instances. I will give you one example. Right. This is also stipulated in section 83 of the trust ordinance as well, where you and I enter into a loan transaction. I borrow some money from you. So, you in giving money, you insist me to keep a security for the money that I borrow from you. So, you insist a deed or a land to be kept as a security in your name to secure this loan transaction. So, the most legitimate way would be that we can execute a mortgage bond or a deed of mortgage, mortgaging my land to you.
Right.
But if we execute a deed of a mortgage or a mortgage bond, if I do not pay you, you need to go before court and prove that I have not settled your loan, and then you have to get the mortgage bond executed through court process. Right. So, that is a little difficult procedure. And when you obtain a loan from a bank, they enter into loan agreements with you and mortgage bonds with you.
Right.
So, that is the accepted practice and that is the law. However, now we have seen a lot of people who are lending money officially and non-officially, money lenders. Money lenders do not want to take the burden of bringing that mortgage bond to courts and to prove it in court and to get involved in that time consuming process. So, what they insist the borrower is, now you write me, you give me a deed of transfer, right? I will keep it as a security. Soon after you settle your loan, I will transfer it to you back. So, it is very simple, very simple. No court process is involved, where I upfront execute a deed in your favor. So, virtually on paper the title or your title has been transferred to you.
Right.
However, the agreement between you and I is that once I make the payment, once I settle your loan, you would write it back to me. Right. In some instances, now these agreements, you know, the agreements with these unprofessional money lenders, most of the time they do not honor.
Yes.
It can be reciprocal, it can go in either way. Sometimes even the borrowers do not honor, but
yes,
it can go either way. But anyway, in most of the instances, money lenders, now when they have the deeds in their hand, they refuse to. They refuse to transfer the property back even after the repayment of the loan. Or
right,
you deliberately avoid accepting the payment, because obviously the value of the property, value of the land is higher than that of
yes,
you had given me. So, in those instances, I have a remedy as a borrower to prove before court that although there is a deed of transfer executed, the intention of the parties was not to transfer the property in the name of the purchaser, and it was merely a security of a loan transaction.
right.
So, there is a procedure and there are certain requirements that I should prove, because otherwise what would happen is every seller would come and say after some time, once the lands are prices are appreciated, would come and say no, I did not intend to transfer this property to the purchaser, it was a loan transaction. So, in order to avoid those unnecessary and unreasonable demands, the law provides that the person who claims that he did not intend to execute a deed of transfer must prove certain aspect, that is by attendant circumstances, that he did not intend to transfer the beneficial interest to the purchaser. What is beneficial interest? Beneficial interest is that, now you might recall that during our very first program, we discussed about the ownership.
Yes.
So, ownership contains mainly few aspects. One is possession, the enjoyment, right. So, now suppose that I write a deed in your favor, on the face of it a deed of transfer, it is outright transfer, consideration has been exchanged between you and I. So, I transfer the property to you, but I remain in possession irrespective of the fact that I have executed this deed in your favor. Now, on paper you hold title,
right,
but I enjoy
the possession,
possession and I enjoy the property. So, that indicates that I have not intended to transfer the beneficial interest to you. Right. So, I still derive the benefits out of that. So, there are certain aspects, criteria to be proved before court, and I can establish that this is not a outright transfer, but merely a document, merely a deed executed to secure my loan.
Right. In that case, you remain in possession in your scenario, that what you have explained. But in that case, if I who have lended the money takes the possession as well. For example, you have taken some money, keeping the land. From a deed of transfer, you have transferred the property to me, and I remain in possession.
You come into possession.
Yes.
So, I give up my possession and I deliver possession to you.
Yes, right. Sum of amount is with you, the land is with me, the title and the possession is with me. Now, after a certain time period, for example, say 5-6 years, you didn't pay me, I am still remaining in possession. Exceeding 10 years, still I am remaining in possession, you haven't paid me. But can you establish in courts, although a large time period, nearly 10-12 years have been lapsed, I have the intention to pay, but still I am in possession, will it come under prescription?
Yes. Now, prescription ordinance covers many areas. However, trust ordinance provides that in terms of constructive trust, the prescription will not apply.
Right.
So, you can claim a prescription technically in terms of trust ordinance even after the expiry of 10 years. Now, before coming into before giving a specific answer to your the question, now possession is not only the factor that has to be considered. There are many other factors should be taken into account to decide whether whether a constructive trust exists or not. Other than possession, the value of the property is also important. Where if I borrow money from you, the document or the instrument, the deed will reflect or it will indicate the amount that I have borrowed from you, not the actual value of the property. So, if the actual value of the property is much more higher than the transacted amount appears on the deed, it gives an inference the existence of a constructive trust. Right. Why did I, if I actually intended to transfer this, why did I transfer this property to a lower value? So, the actual value is this, but the transaction value is this. So, the disparity or the difference between the actual value and the transfer value implies that there exists a constructive trust. And some other aspects of the payment of notary fees. These are very common things and very simple things. When you buy a land, generally it is the purchaser who pays the notary fees. But in money transactions, the borrower has to pay the notary fees because it is his burden. So, technically in constructive trust cases, notary fees have been paid by the seller.
Right.
Why? Because he was the one who wanted the money. So, he paid the notary fees as well. So, there are aspects like that we can consider, the courts will consider to arrive at a decision with regard to a constructive trust.
That means no prescription if we can claim that the payment of notary fees, some simple things,
yes,
and even undervaluing that property, for example 2 million, but the deed is being transferred for 100,000. So, no prescription if they can establish that particular facts clearly, still they can claim the ownership of the property.
Exactly. You can institute a constructive trust action, and you can prove on balance of probability that the intention of yours was not to transfer this. You did not intend to part with the beneficiary interest. Right. And there is another type of constructive trust where, now this is with regard to loan transactions. The other type of constructive trust are, now I purchase a property in your name. That also often happens, and now it may be for various purposes, right? Let us say I need to avoid any payment or tax, right?
In the incorporation, the veil of incorporation being misused, likewise.
So, I wish to conceal that transaction. No, I do not wish to pay tax on the purchase. So, what I do is I purchase in your name, but the transaction, but the consideration that the amount is paid by me.
Right.
The land technically on paper is in your name, but I put up a building. So, I am in possession. So, I take the beneficial interest.
Right.
So, I can prove that if you claim that this land is mine, I have a deed, I can prove that I was the one who provided the consideration and I am the one who is enjoying the property, and I did not intend to give you the beneficial interest. Right. So, that is also another form of constructive trust.
විස්සයි විසිතුන පාසැල් ක්‍රිකට් සමය උණුසුම් කරමින් දිගහැරෙන කාට්මන් කුසලාන මහා ක්‍රිකට් තරගයේ 127 වන ප්‍රයාම. ශාන්ත බෙනඩික්වරුන්ට එරෙහිව වෙස්ලිවරුන්ගේ බෙන්ස් වෙස්ලි මහා ක්‍රිකට් ගැටුම මාර්තු 17 වනදා සහ 18 වනදා කොළඹ සරවනමුත්තු ක්‍රීඩාංගණයේදී. සජීව විකාශය ක්‍රීඩාවේ ප්‍රමුඛයා channel I වෙතින් උදෑසන 9:30 සිට.
So we elaborated much more on constructive trust, and so let's emphasize now on selling a property. If the property belongs to a minor, can we sell that property?
Yes. Now, if a property belongs to a minor, now a minor can become a owner of a property. Now, how can a minor become a owner of a property? Because minors cannot technically get involved in contracts, transactions, but it can happen in many ways where a minor can inherit it. Minor can inherit ownership, and also parents may have purchased a property in a minor's name. So minor can become an owner. Property belongs to a minor can be sold, but there is a severe restriction on that. Because now if you want to sell a minor's property, you must take a court order. Without the intervention of court, minor's property or any property, any immovable property belongs to a minor cannot be sold or alienated. It should be done through a court process. You have to institute an action in court and take permission from court, and then only you can sell minor's property.
Right.
Now, take for an example, now father dies, mother gets half share and 2 minor children get the balance half share. Now, mother wants to sell this property and she wants to purchase another property. Now, she can't sell the portions belongs to the minor without a court order. So, what is the procedure? She has to apply from court permission. Court is not giving permission without properly evaluating facts. First, you have to establish the value of the property, because you know why. You can undervalue a property.
Yes.
So, in order to safeguard the rights of the minors, the court would call for a valuation report, and then purchasers affidavit to confirm that the particular property is being purchased for this value, and also that once it is used, now it can be sold for many purposes. Now, let us say mother says, okay, I want to sell this property, and I need to buy another property from elsewhere. In that event, the mother must show that this is the property that I am intending to buy. The seller of this property has agreed to sell this to this amount, and this is the draft deed where undivided half has been given to the children.
Right.
So, it is a long and complicated process. So, you can sell minor's property, but subject to the strict supervision of court. You may know that it is because the district court is the upper guardian of minors. So, court has to ensure that no harm is done to the rights of the minors. So, court through that process, court ensures that the title rights of the minors are secured.
Right. When it comes to foreigners, selling lands to foreigners,
it's prohibited. There is a law called lands restriction on alienation. It prohibits selling of lands to foreigners. Now, foreigners therefore cannot purchase lands. However, and foreign companies also cannot purchase lands if the foreigners owns more than 50% of the shares of the company. However, you can utilize lands on BOI for BOI projects, and some other exceptions are there, but you cannot sell lands to foreigners and foreign companies. So, it is prohibited.
Right. So, when it comes to state grants, permits, what is the scenario, the legal applicability there?
Yes. Now, in regard to state lands, now state lands belongs to state. So, state lands can be alienated to citizens of the country based on permits and grants. So, the law applicable in relation to grants and permits are stipulated in the Land Development Ordinance, Crown Grants Ordinance, and there are a number of legislature governing those aspects. So, once it is given by way of a permit, the permits are of 2-3 varieties. It can be an annual permit, or it can be a long term permit, and if it is a grant, then it is under the signature, under the hand of the president, the grant is being given. All state land, the permit holders and the grant holders can alienate those state land to a third party, subject to the approval of the divisional secretary of that area.
Otherwise, without that approval, they can't?
No, they cannot, because now there are specific purposes. Now, if you given a land in terms of Land Development Ordinance, there is a purpose of giving you a land. It is not for your financial benefit. You must cultivate, you must develop the land, and that is the purpose that you have been given a land under Land Development Ordinance. But you desire to sell it to a third party, it is permitted, but you have to take sanction from the divisional secretary, and divisional secretary gives a certificate and his permission, and that permission letter has to be attached to your deed.
Right, that is, there is a specific procedure, and
Yes.
adhering to that procedure we can proceed forward. And so there are some state lands, if some person specifically, that now these days we hear certain cases, land belongs to state, but we have put up cultivations and certain people try to grab those things in illegal manner. Will that prescription right adheres to that people?
No. Not at all, because state lands are free of this provision, because state lands are not subjected to the prescription ordinance. You cannot claim prescription on a state land, and so therefore, even though you may have occupied a state land for 100 years, you cannot claim prescription against the state. So, that is prohibited by law. So, there is no question about claiming prescription. You cannot, a squatter or illegal possessor, or they may have continuously possessed, they may have uninterruptedly possessed, they may have adversely possessed against the rights of the state, but you cannot claim prescription on state land. So, the state is always at the liberty of expelling these people from state lands by instituting a proper action under recovery of state lands in the magistrates court, and take a order to eject them from the land.
Right. So, in certain cases we hear some people selling those particular lands in a way of deed of declaration. What is the deed of declaration?
Well, deed of declaration is that, now it is very common that people execute deed of declarations, but the value of a deed of declaration is seriously in question, because deed of declaration is in a way a self-serving document, where you declare that you are the owner, right? Anyone can do that. With or without having any ownership or any right or title to a property, anyone can just execute a deed of declaration and say, I am the owner, right? So, deed of declarations have very little value. However, now say that I execute a deed of declaration in relation to a particular land plot, and I continue to remain in possession for a longer period of time. So, if there any dispute arises in the future, that I might be in a position to prove my prescriptive title by producing that deed of declaration as well, to prove that I executed this deed of declaration, declaring that I have been in possession for over 10 years. Now, the execution of this deed of declaration is also more than 10 years old. So, now I have proof that I have been in possession for a period more than 20-30 years. So, it may be used as evidence in a court of law, but the whether it is considered as valid evidence or not will be done by the judge at the conclusion of the trial.
Yes, right. Okay, so thank you very much. So we had some insightful discussions, like very interesting regarding land. This is the final episode of the law relating to land. We did many programs, 3, this is the 4th, and we gave you many insightful ideas and suggestions, and even we gave you the knowledge regarding the land, to not to let you in trouble simply, because you can understand with these explanations, if you are in trouble with regard to a certain disputes, if you are legally entitled, but you must go in front of courts and solve this matter. So, ladies and gentlemen, thank you very much for watching, and thank you very much, sir, Mr. Sapumal Bandara, attorney at law, for joining the discussion and giving your fullest support for the success of this program and discussing on the matters relating to land. So, stay tuned with Law and Order. We'll be sharing many more interesting topics in the future as well, to give you the knowledge to not to let you in trouble. So, thank you very much. Have a pleasant day.